Judgment in the matter of the Kingdom of Bahrain against Shehabi and another.
Lord Lloyd-Jones will explain this judgment.
This appeal concerns whether the Kingdom of Bahrain can rely on state immunity under Section 1 of the State Immunity Act 1978 in respect of proceedings brought against it by Dr. Saeed Shehabi and Mr Mr Mohammed, or whether the proceedings fall within the exception to immunity created by Section 5 of the State Immunity Act. Section 1 of the State Immunity Act gives foreign states immunity from the jurisdiction of courts in the United Kingdom subject to certain exceptions. And the exception relevant to this appeal is Section 5, which provides immunity for proceedings relating to death, personal injury or property damage, quote, caused by an act or omission in the United Kingdom, unquote. Article 11 of the European Convention on State Immunity, the European Convention, to which the United Kingdom is a party, accepts from immunity those proceedings which relate to redress for personal injury or property damage, quote, if the facts which occasioned the injury or damage occurred in the territory of the state of the forum, and if the author of the injury or damage was present in that territory at the time when those facts occurred, unquote. Dr. Shehabi, a pro-democracy journalist and activist, is a leading figure in the Bahraini opposition movement who has lived in the United Kingdom since 1973. Mr. Mohammed is an activist for human rights and democracy in Bahrain who has lived in the United Kingdom since 2006. The appeal has been heard on the basis of assumed facts. Dr. Shehabi and Mr. Mohammed allege that from around September 2011, persons acting on behalf of Bahrain hacked or infected their computers with a spyware program. They both allegedly suffered personal injury in the form of psychiatric harm upon learning of this in or around August 2014, following the publication of information about the spyware program. It is alleged that this amounts to harassment, contrary to the Protection from Harassment Act 1997. They argue that their claim falls within the personal injury exception to immunity under Section 5 of the State Immunity Act. It's common ground that Dr. Shehabi and Mr. Mohammed's claim would not fall within the exception contained in Article 11 of the European Convention because the author of the injury or damage was not present in the United Kingdom. Bahrain's agents were likely operating from outside the United Kingdom, and the spyware was operated via a server located in Bahrain, while Dr. Shehabi and Mr. Mohammed and their computers were in the United Kingdom. The High Court refused Bahrain's application for a declaration of immunity. It held that Section 5 does not require that the author of the personal injury or property damage be present in the United Kingdom. In addition, there is no requirement that every act or omission which caused the injury or damage has to take place in the United Kingdom. It is sufficient for there to be a substantial and effective causative act or omission. The Court of Appeal dismissed Bahrain's appeal. It considered it artificial and unprincipled to treat the act when a person located abroad uses a computer to infect a computer in the United Kingdom with spyware as having taken place abroad and not in the United Kingdom. Nor did the Court of Appeal find it necessary for all acts of the foreign state to have taken place in the United Kingdom. Bahrain now appeals to the Supreme Court. The Supreme Court, by a majority, dismisses the appeal. Lord Lloyd-Jones, Lord Hamblin and Lady Simler give the majority judgment. Lord Leggett and Lord Burrows give dissenting judgments. The majority state that the words of Section 5 are the primary focus. Section 5 is expressed in straightforward language. It requires an act in the United Kingdom which is causative of personal injury or property damage. As a matter of ordinary language, there's no requirement in Section 5 for the act or all acts to be in the United Kingdom, still less is there any express requirement of presence in the United Kingdom for the author of the relevant act. The words caused by an act or omission naturally import the legal requirements of causation. In other words, a legally causative act is required. This will exclude acts which are too remote or insignificant, but no further qualification is necessary. There's no good reason why Section 5 should be read as meaning only the initiating, precipitating, or responsible act or omission. The central issue in this appeal is whether Section 5 requires the presence of the responsible actor in the United Kingdom at the time of the act that is causative of the personal injury or property damage. Section 5 must be understood in the light of the State Immunity Act. One reason for its enactment was to enable the United Kingdom to ratify the European Convention. While the State Immunity Act was intended to give broad effect to the European Convention, it was not intended to implement it precisely. For example, sections 3(1)(a), 4, 5, 9, and 13, subsection 4 of the State Immunity Act have a wider scope than the corresponding provisions in the European Convention, including the use of different jurisdictional linking factors from those in the European Convention. Article 11 of the European Convention employs two linking factors. The facts which occasioned the injury or damage must have occurred in the territory of the state of the forum, and the author of the injury or damage must be present in that territory at the time when those facts occurred. Section 5, by contrast, is concerned with an act of the foreign state causative of the relevant harm and contains no express presence requirement. The majority consider that the words of Section 5 are not reasonably capable of bearing the same meaning as the words of Article 11, which impose the presence requirement. The natural meaning of the word act in Section 5 is not limited to the physical movement of a human being. The principle of consistent interpretation, referring to the presumption that statutes should be interpreted in conformity with the United Kingdom's international obligations, has no application here because the departure from the European Convention is deliberate. If it had been Parliament's intention to require a presence requirement, it is inconceivable that this should have been omitted. Nor can its omission be explained by any difference in drafting styles. It was open to Parliament to include a presence requirement without adopting the exact language of Article 11. The omission of a presence requirement in Section 5 is clear and deliberate, and this is determinative of the appeal in the view of the majority. The United Kingdom has the power to derogate from the European Convention and exclude immunity in a wider range of cases under Article 24(1). Article 24(1) provides that this is without prejudice to the immunity from jurisdiction which foreign states enjoy in respect of acts performed in the exercise of sovereign authority. This provision does not exclude from derogation all acts performed in the exercise of sovereign authority. Article 11 itself does not distinguish between sovereign and non-sovereign acts. The effect of Article 24(1) is that the United Kingdom may, consistently with its obligations under the European Convention, deny immunity in wider circumstances than those identified in the European Convention, provided that in doing so it does not deny immunity in respect of such sovereign acts for which customary international law requires immunity. While it is unnecessary to express a concluded view on the status of customary international law, there was a reasonable basis in customary international law for the United Kingdom to conclude that it could lawfully give effect to a territorial tort exception in Section 5, which did not distinguish between sovereign and non-sovereign acts, and which employed different jurisdictional linking factor from that contained in Article 11 of the European Convention. There is a substantial body of state practice supporting the existence of a territorial tort exception applicable to sovereign acts, including international conventions, national legislation, foreign judicial decisions, as well as academic commentary. Even if no territorial tort exception exists in customary international law, this does not support Bahrain's interpretation of Section 5. Section 5 of the State Immunity Act and Article 11 of the European Convention do not distinguish between sovereign and non-sovereign acts. Therefore, on this basis, Section 5 would still permit the exercise of jurisdiction in breach of customary international law, even if interpreted in conformity with Article 11 of the European Convention. To read down Section 5 to comply with the claimed position in customary international law would require that sovereign acts performed by foreign state agents present in the United Kingdom be entitled to immunity. This would clearly conflict with Parliament's intention. There is no particular reason why presence should define the limits of the exception as a matter of customary international law. The purpose of the presence requirement arises from concerns as to jurisdiction, rather than immunity. The relevant consideration as regards immunity is whether the linking factor establishes a sufficient connection with the forum state. Section 5 already requires satisfaction of a powerful linking factor justifying a denial of immunity, namely an act by the foreign state within the territory of the forum state. This is consistent with the principle of a state's sovereignty over its own territory. By way of conclusion, therefore, the majority consider that on the interpretation of Section 5, the meaning of an act includes an act carried out using a device or other automated or remote means, even if the person responsible for carrying out the act is not physically present at the location where the act takes place. Therefore, hacking into a computer located in the United Kingdom by a foreign agent situated abroad is an act in the United Kingdom under Section 5. In the present case, the acts involved surveillance of Dr. Shehabi and Mr Mohammed on the assumed facts. That surveillance took place in the United Kingdom. It involved a serious and intrusive interference with the territorial sovereignty of the United Kingdom. It makes no difference that surveillance is carried out by means of computer hacking rather than by a human. The case therefore falls within the exception to immunity from jurisdiction contained in Section 5 of the State Immunity Act. For these reasons, the appeal is dismissed.